Good afternoon, everybody. My name is Sarah Pinder, and I'm a barrister and joint head of team with my colleague Samina Iqbal at Goldsmiths Chambers. Thank you for joining us. We're going to be covering medico-legal reports and their importance in asylum and immigration proceedings today. So before I come on to introducing our eminent speakers, I feel very privileged to be accompanied by three amazing women today. I'm going to just go through a few bits of housekeeping. The first is that, as you just heard, this new Zoom lady, this webinar is being recorded. We will make the recording available after today to anybody who's not able to join us live or anybody who does want to watch back. And that will be available on our website, and you'll be notified through our website, but also on the email notifications through Eventbrite. And similarly, the slides that we've prepared for some of the parts of this webinar will also be made available that way as well. The last bit of housekeeping is just if you've got any questions for us and for the speakers, put them in the Q&A box, which you find at the bottom of your screen. I will try and keep an eye on the chat box as well, but it does help if you can just put those in the Q&A box. We will have some time at the end of the webinar for those questions. So if you have a specific question directed to a specific speaker, it may help to put their name there so that we can field accordingly. But obviously, if you're not sure if it's relevant to any of us, then that's fine as well. And as I said, Q&A box. And we will try, if we manage to take a particular question at a point in the talk, but that depends on our multitasking abilities, really. So without further ado, I just want to introduce our first speaker. This is Dr. Juliet Cohen, Head of Doctors at Freedom from Torture. So we're very pleased to be able to be joined by Dr. Cohen and Freedom from Torture. You may have obviously, hopefully heard of the organization. They are incredibly helpful in terms of the reports and the research that Freedom from Torture have published. So go to their website to look at those in particular against certain countries. I'll put the link for that in a moment. And Dr. Cohen is going to look at, in particular, commissioning and using medico-legal reports, particularly whilst we've been affected by the pandemic. And we'll also look at the Home Office policy and the use of that and holding that to account in effect. After Juliet, we will have Charlotte Bayati, colleague in Chambers, who represented KV with other barristers and led by Richard Drabble QC. So Charlotte will take us through a bit more about KV, the guidance from the Supreme Court on reports, how they are useful, in what way they may go to assist or corroborate a claim. And then we will have Samina Iqbal, also a colleague in Chambers, looking at unlawful detention claims and in particular how to make use of medical evidence. I'm just going to do a short plug for Samina's book. Here again, I'll put a link in the chat box, but basically a very useful guide, accessible guide on unlawful detention claims. If you're expert in the area, it's incredibly useful. If you want a way into the area, it's also very useful and accessible. So do have a look at that if you have any interest. And then I will finish up just with a tiny look at the practice directions and really just preparing instructions to experts for those reports and what the future may hold in terms of the government's proposal. So I hope you will find it useful. And now my turn to shut up, and I will pass on to Juliet.
Thank you so much. And it's a pleasure to be here today. So I'm going to talk, first of all, just a little bit generally about instructions for an MLR. As Sarah mentioned, Freedom from Torture has a referral form on the website, but and you may already know all of this, but what's most helpful to us when we're looking at new referrals is to get a good outline of the case, what's going on. And for an organization like Freedom from Torture, which is has a charitable remit to care for torture survivors, we need to understand why your client would come within that remit. So there's a little box on the form to explain what our remit is, and for you to explain how your client falls within that remit. We really need to see all the documents that are relevant that you have in the file, what stage of their application they're at so far. And we want to have everything up until then, because otherwise everybody just spends a lot of time with a to and fro of, well, what about the CEF? And haven't you got that other witness statement? And obviously there are some very complex cases coming up these days with multiple further submissions, but the more documents that are organized in the initial referral, the easier it is to assess what's needed in that case. And what we then need to know is what there might be for the doctor or therapist to document the scars, the psychological impact, and what sort of medical records you might be aware of that already exist to corroborate perhaps those cases. But relevant medical records is a bit of a thorny issue right now. It's a kind of be careful what you ask for sometimes, because I've seen reports be criticized where the doctor didn't have access to the medical report evidence, the GP medical record or hospital records, with judges saying they should have considered this. But sometimes we get sent a bundle of 600 pages of medical records, and this adds really a lot of time to a report to work through those, to check for things. And of course, all of those GP medical records in particular are just notes that the doctor has made. They probably didn't have an interpreter, or perhaps they had a relative. They haven't been concerned about making a really accurate record of what the person said happened to cause their condition or scar that they're consulting the doctor about. So it's quite common to find new discrepancies and inconsistencies within the medical records that we then have to address in the report. So there can be some really great corroboration, but there can also be some unexpected sort of time bombs ready to explode. I had a case of a woman whose father had died twice, which was tricky to explain. Yeah, so you never know what you're going to see. We also get a lot of additional questions now in letters of instruction, particularly about future risk, suicide risk, the ability of that person to live independently if returned to the country of origin, their ability to access treatment they might need if returned. And I understand that this kind of preempts cross-examination that the medical expert usually isn't present to take part in. But again, they do add a lot of hours of work, and you can debate whether they also contribute to a rising standard of proof when the standard of proof is meant to be very low. Do we need to have all of those extra questions? I'm only sort of throwing this out a little bit provocatively just to say that you might sometimes get some pushback. You might sometimes find your expert hasn't answered all the questions that you wanted. Perhaps it wasn't clear to them why they needed to answer those. So the clearer you can be about what questions and why you will need those answers, the better. And we also need to know time frame, hearing dates, what's the urgency, and if you have any particular concerns about your client's vulnerability, whether they'll be able to travel, how they will cope with describing their torture. If you know that when you tried to take the witness statement, you had to call an ambulance, that's really helpful for us to know. So in COVID times, when the lockdown started, we planned to take what evidence we could remotely. And we started doing interim reports, just making a psychological assessment so that people who urgently needed some evidence to put forward would have the beginnings of their medical legal report, even if it couldn't be complete, and with an outline of what we hope to then complete in a follow-up appointment when we could make a face-to-face examination for the physical evidence and to review the mental health assessment. This wasn't easy. Initially, we had clients who generally just had a telephone without smartphone, no Wi-Fi, no video access. So we trained doctors to try to make a telephone-only assessment on a voice call. There were problems with privacy and confidentiality, the people with some roommate asleep in the room with them, young children present, people walking around a park while they had their assessment. There are all kinds of difficulties that came with that. As soon as we started it, we planned to audit the process because it was a departure from our normal way of working, and we wanted to check how it was working, whether we thought the evidence that we were able to gather in this way was going to stand up, whether there were going to be problems, and what happened later when we did a follow-up assessment, what new information might come out. So we did a sort of 360 audit, asking the doctors, the clients, the interpreters, our own review team, what their impressions were of how well the process was worked, qualitatively and quantitatively, what sort of information we were getting, what the doctors felt they were not able to get. Because we were very, very conscious that when you've got a client alone in a room with no access to their therapist, no support services, the middle of lockdown, you can't push them too much. You can't risk someone dissociating or being acutely re-traumatized and then going out and harming themselves. So we excluded, even from the documents, some people that we felt their mental health just looked like it was too unstable to go through this process. And then we would discuss that with the legal representative as to how we could proceed. People who were suicidal, people with psychotic symptoms, people who had a history of dissociations would be ruled out. Lone parents of small children would be ruled out. So some people we just couldn't assess. One or two slipped through that net, and then the assessment had to be stopped because they became too distressed or unwell during the process. And then we've been able to carry out face-to-face follow-up on, I think, everybody now who needed it. So there are reports in the system now that we don't yet have outcomes for, that will be either in two parts, with the initial remote and then a follow-up face-to-face, or only remote if they weren't completed. And we hope that we put sufficient caveats on those reports that they would do the job that we're intending to do, to present what evidence it was possible to get, while leaving the door open that it may well be that there is more to come, more disclosures that people can't gather in this remote way. I think you probably all remember there's been so much in the press again recently about remote consultations medically. Initially, everybody was saying, yay, this is great, GPs can do all this remotely, it's better than queuing up. And those who resisted it or said, no, hold on, there are problems. You can't get the non-verbal cues. You can't really understand people's body language properly. You don't know what you're missing. You can't really probe them. We got ridiculed as Luddites almost. But now the tide's coming back and everyone's beating up the GPs for not seeing people face to face and counting up all those misdiagnoses. And I think there is a genuine reason to be concerned about this. Even though it is a time saver. And I think that there is a reason to copy across that concern also to remote hearings in the tribunal, and to the asylum interviews that are conducted remotely, bail applications held remotely. There are a lot of very vulnerable people out there who don't deal well with video link evidence. There's a lot of difficulties for interpreters to work in this way, whether they're also remote from the client applicant or whether they're sitting with them, but they then can't necessarily see everybody else in the room because of the way the camera's positioned. People are missing out on body language. And I think they're also often missing out on a lot of the things that are said in a hearing, because there isn't simultaneous translation, and it's much harder to ask people to pause for a moment while something important is translated. We know that many of these people have mental health problems. Their concentration is poor and they don't follow proceedings very easily, particularly when having to wait for an interpreter to explain something to them. And I think remotely, you're almost excluding them from participating in their process. I'm conscious of time. I think I might just quickly move on now to the asylum policy instruction, which relates to Medical Foundation reports. And now, since the new edition, which came out in, I think, August of 2021, applies to other medical reports as well. There used to be two separate ones, but they've now been joined together. And all the key points from the old API are preserved. And there are some really, really important things. One of the things that I do at Freedom from Torture is, where we've submitted a medical report and it's been refused, the legal representative often comes back to us and says, would you like to comment on how the medical evidence was treated? And in this situation, I will usually write a clinical response letter. That's the name we give to a clarification of misunderstandings that the Home Office case owner, and sometimes the judge, has made about the medical report's evidence. And when I write those, I refer repeatedly, literally paragraph by paragraph, to this API. It's so important, and it sets out some really, really key guidance, which, if followed, the medical evidence would generally carry the weight that it should and be understood properly. So it sets out very clearly that the Home Office should suspend a decision if there's a medical report arranged with a reputable provider, unless they're minded to grant anyway. It reminds decision makers of the low standard of proof, with being a reasonable degree of likelihood, and that they shouldn't give little weight to an MLR where the writer has the required experience. It recognises the standing of the Istanbul Protocol, and in particular in relation to the absence of physical evidence or a specific psychiatric diagnosis, which cannot be taken as meaning that the person wasn't tortured. We also got them to include the important safeguard that an MLR that's not obviously referencing the Istanbul Protocol can still be given weight and can still provide evidence of torture, even though they prefer to see reference to the IP. They are not allowed to exclude medical evidence that doesn't reference it. They're reminded that they should consider all evidence in the round. And this is really important, particularly I find in the further submissions case, where they tend to rely on an adverse credibility finding from previous decisions and then say, therefore, the medical report is only relying on the history, which we found to be not credible, and therefore we don't give any weight to the findings. And this API reminds them that they must consider the evidence in the round and not do it in that way. There's a reference to KV, but I won't touch on that because we're going to come to KV in a moment. But the other really key area, which follows, I think, page 22 in the new API, is about clinical judgments. And it instructs the case owners that they should not make clinical judgments, and sets out a number of examples in a non-exhaustive list, particularly about the causation of physical or psychological injuries, questioning the accuracy of a diagnosis, making selective quoting from the report or from diagnostic criteria. They're not to substitute their own opinion on late disclosure or discrepancies in the testimony. They're not to speculate about the amount of detail someone should remember their trauma in. They shouldn't make their own subjective opinion about claimants' behavior, particularly about seeking treatment or refusing consent to an examination. They shouldn't use the statement that someone feels well to undergo their interview or to continue an interview to subsequently dispute medical problems that have been identified in the medical report, and so forth. So all of this stuff is just so useful. I use it all in the clinical response letters, but honestly, anyone can use it. There's no reason for many of these response letters that the legal representative couldn't have gone to this API and done exactly the same job to refute the assertions made in these particularly poorly drafted decision letters. One thing that's interesting that came out of the Proving Torture report that Freedom from Torture published in 2016, in which we highlighted the problematic assessment of medical evidence that was going on, is that we got to participate in joint training with the Home Office for their decision makers and how to better understand medical evidence. We've been doing that for about 2.5 years. It's been a very slow, creaky process, but we've trained quite a lot of decision makers. And I think, although it's a bit early to really draw substantial conclusions, overall, I think there has been a lot of improvement in the initial decisions. The further submissions team haven't had that training. They're a completely separate team that runs with its own training, but we're going to start training them in December. So I'm hopeful that we might then start to put some better information into those guys and improve their decision making. I think I probably ought to pause now and hand over and maybe come back at the end for questions. Thank you.
Thank you, Juliet. That's great. So in terms of yeah, the order, we're going to turn now to Charlotte, and I'm going to share my screen to allow these slides to do that. So if you can just bear with me, everybody, that's going to happen now. And while I do that, I'm also reminded, I forgot to mention that Freedom from Torture intervened in KV as well, was one of the 3 organizations intervening. So is that not right?
Early on they did, but then they, okay. And then later on, it's sort of in between, they didn't. Okay, it was Helen Bamber as well.
In the long line of litigation. Super, so we're going to just go through really fast for the slides, and there we are for the start of KV for the guidance, and I'm handing over to Charlotte now.
Thanks very much, Sarah. Good afternoon, everybody. I'm going to dive straight in because I'm conscious of time. The importance from a legal perspective of medico-legal reports and those reports which comply with the Istanbul Protocol cannot be overstated in support of an individual's claim to have been tortured, in particular in support of an asylum or human rights claim, or indeed potentially a trafficking claim. Evidence of a suitably qualified and experienced doctor which corroborates an individual's claim to be tortured is significant. Indeed, one could go so far as to say that where there has been a claim to have been tortured and there is physical evidence, such as scarring on an individual's body, or evidence of trauma impacting on their mental health, a report will be vital. Whilst the courts have been careful to make clear that the ultimate decision on whether an individual's account of being detained and tortured is credible, is one for the fact finder, in our case, the Secretary of State or indeed the tribunal. Nevertheless, it has also been acknowledged that the expert has the expertise and is not going beyond his role in giving his or her own conclusions on whether the individual has been tortured or whether he or she is of the opinion that their scars were caused by torture or the trauma they suffer as a result of torture. Thus, the role that a medical report can play in the assessment of credibility is significant and due weight should be attached to it. Turning to the case of KV, which was heard and decided by the Supreme Court in 2019, the Supreme Court gave consideration to the value and weight to be attached to medico-legal reports when assessing the credibility of an individual's account. In this case, the issue had arisen following the upper tribunal's decision to give guidance on whether a doctor should give consideration to the issue of whether the scars on an individual could have been inflicted by self-infliction by proxy, or otherwise known as SIBP for short. This is something that had been creeping in to tribunals' consideration of Tamil cases in particular, based on an unsourced reference in an old report from the Secretary of State, which then disappeared. Importantly, though, for KV and other Tamil asylum seekers in particular, the Supreme Court did put to bed the notion that every medical report should expressly consider whether SIBP was more than a remote possibility. Indeed, when the case went to the Court of Appeal, it had already concluded that the upper tribunal should not have given that guidance on this issue, and that SIBP was indeed very rare, but the Supreme Court made that very clear beyond doubt. However, the Supreme Court's judgment, in my view, is also significant for other reasons. In particular, it made clear the importance of the role of medico-legal reports in the assessment of credibility of an individual's claim to have been tortured. The majority of the Court of Appeal in KV had narrowed the value and role of medico-legal reports in asylum claims, taking the view that a report could only assess and provide an opinion on the level of consistency of an injury with the mechanism claimed to have been used to inflict that injury. And in the case of KV, it was being burnt with a metal rod. And a report should not look at the circumstances in which that took place, and more significantly, whether that applicant had been tortured. Indeed, the majority took the view that a doctor giving an opinion on the likelihood that the individual had been tortured in the manner claimed went beyond his or her expertise. Thankfully, Lord Wilson, speaking for the Supreme Court, made very clear that this was incorrect. And indeed, if that was the purpose of an MLR, it would add very little to an individual's case. And I've put up on the slide paragraph 20 of his judgment, which is of particular relevance on this. And you'll see those passages are underlined, wherein he states in particular, decision makers can legitimately receive assistance, often valuable, from medical experts who feel able, within their expertise, to offer an opinion about the consistency of their findings with the asylum seeker's account of the circumstances in which the scarring was sustained, not limited to the mechanism by which it was sustained. And then he went on to look at KV's particular case, where there were two areas of scarring which were different. The scarring on the back were very defined, whereas the scarring on the arms were slightly blurred. And indeed, the doctor, Dr. Zapata Bravo in this case, had looked and contrasted that scarring and gave his opinion on it. And indeed, Lord Wilson stated at the end that when he proceeded to correlate his findings of a difference in the presentation of the scars on the back and those on the arm, taking account of how the alleged torture had proceeded, he was giving assistance to the tribunal of significant potential value, and it never suggested that he lacked the expertise with which to do so. That report and that distinction was highly significant in this case on particular facts. Now, the other point of importance from Lord Wilson was that the reconfirmation, if you like, of that medical experts should make their assessments of injuries or trauma with reference to and applying the Istanbul Protocol. And indeed, they cited with approval SA Somalia and RT Sri Lanka, which had endorsed the comments of the Court of Appeal in SA Somalia. This was because in KV, the majority of the Court of Appeal had suggested that the practice direction of the tribunal in relation to expert evidence was the only document that experts should consider and apply. But Lord Wilson said no. Whilst the practice direction was important and is important, it did not expressly deal with medico-legal reports relating to torture, and it made clear the importance of the role of the Istanbul Protocol and its use and application by doctors when preparing medico-legal reports. So what can we take from KV, and in practical terms, how does it assist doctors when they are assessing individuals and making their reports? Well, it makes clear the importance of legal reports assessing scarring and or trauma. And their life.
Sarah, we might have lost Charlotte there.
Apologies, everybody, for slightly patchy connection there. So I think let's allow Charlotte to join us back up, and we may go back to her slide after. Samina, would you be able to start? I think we were on,
I can.
Yeah, we were on Charlotte's last slide. So we'll come back to that, and apologies everybody for that.
That's quite an interesting slide, actually. She covers another case after maybe Sri Lanka, but when Charlotte, back.
I'm back. Sorry, I do apologise to everyone. It booted me out, and then it automatically let me back in again. Sorry, I was just about to say that the list, if you like, about the detail of what would be important in a report, I was going to address in a moment once I'd gone to MN. And the Secretary of State, which was a judgment of the Court of Appeal in relation to trafficking. They very helpfully in that judgment set out at paragraph 121 onwards consideration review of relevant authority on the issue of medico-legal reports. Now, in particular, in MN, they gave consideration to the line of authority that had preceded them, so to speak, on the issue of medico-legal reports, and summarised the position there. They summarised 6 points, essentially, and in brief. First, that the decision whether the account given by an applicant is in the essential respects truthful has to be taken by the tribunal, the decision maker, on the totality of the evidence viewed holistically. And that seems to be replicated also in the API referred to by Dr. Cohen in terms of the need to look at everything in the round. Secondly, where a doctor's opinion properly understood goes no further than a finding of mere consistency with the applicant's account, it is necessarily neutral on the question whether that account is truthful. However, at point 3, they say, it is open to a doctor to express an opinion to the effect that his or her findings are positively supportive of the truthfulness of an applicant's account. And where they do so, that opinion should in principle be taken into account. And fourth, such an opinion may be based on physical findings, such as scarring, but it may also be based on an assessment of the applicant's reported symptoms, including symptoms of mental health and/or of their overall presentation and history. Then, and I've lost point 5. I really have lost point 5. Bear with me. Point 5, the weight to be given to any such expression of opinion will depend on the circumstance of the particular case. It cannot be determinative. And finally, 6, one factor bearing on the weight to be given to an expression of opinion by a doctor that the applicant's reported systems support their case, that they were persecuted or trafficked, is whether there are other possible causes of those symptoms. Now, what they did say at this point also was that if the expert, for example, has not considered that question that they haven't considered an obvious potential cause, that does not justify excluding the report. It may diminish the value of it, but it doesn't justify exclusion. And I emphasize that because often we see in cases that we do that where a doctor has failed to consider what they can believe to be an obvious alternative and discarded it, you quite often find judges then basically ignoring the report, and that would be wholly inappropriate. Also of interest in MN was that the Court of Appeal referred to other types of evidence that weren't from doctors, from people who have experience with survivors of trafficking or torture, and said that this was also important evidence that should be taken into account. So, bringing all of this together, in practical terms, and I'm sort of going back to those points at the top now, the important issues, really looking at KV and what was said in MN, referring back to previous authority, in my view, MNR, which sets out in detail those points listed, the circumstances surrounding the claim deal treatment and the claim deal treatment itself, a full assessment of all injuries, applying the Istanbul Protocol in assessing likely causation, including other possible causes and potentially discounting them, a consideration as to whether an individual may be feigning their symptoms, and also a consideration that an individual's account is not taken at face value, but is based on a physical and clinical assessment of the individual before them. Now, for a doctor, that might go without saying, but for a judge, it's important that that is said. And overall, a conclusion on the degree of consistency with the individual's account of torture. So really, to conclude, I think my message to you all is that an MLR has potentially significant probative value, and that has been recognised by the courts in any assessment of torture if it follows and applies the Istanbul Protocol, in particular, requiring consideration both of the level of consistency of injury with the torture claimed and consideration of other possible causes. And in any case where there is physical evidence of torture or psychological evidence of mental health linked to past torture, reports should be obtained in support of that individual's claim they are highly material to any assessment of an individual's case. And sadly, it's got to the stage where if there has been a claim, a lack of report potentially may be viewed adversely, wrongly, potentially, but that is where we are with this. And thank you very much for listening to me. I'm sorry, I do apologise if I spoke too fast.
Thank you, Charlotte, that was great, thank you. So over to Samina with Rule 35.
So Rule 35 reports, everyone. I think everyone's going to be very familiar with Rule 35 reports. We see them often in asylum claims for individuals who are being detained. But before we get to Rule 35 reports, where does the power, or where does that come about? How do they come about? Well, anyone who is being held in detention under Rule 34, and it's what I flagged up for you there, most of our links, our hyperlinks are, so most of the highlighted links are hyperlinked, which means it will take you to the source material. So as I've highlighted there, the detention centre rules will take you to the detention centre rules and Rule 34 in particular, but that's where the power for a medical examination on admission to the detention centre comes from. And likewise, if you're in a short-term holding facility, then there are similar detention centre rules. I'm not going to look at those in any detail, but it's for me to flag it for you so you know where to look if you are looking at your client who's being held. Now, often a lot of solicitors are now dealing with detention claims post individuals being granted asylum claims and so on, but the importance of medical claims still, medical legal reports still remains the same, because it's mandatory under Rule 34 for each detainee to be given a physical and mental examination within 24 hours of their entry into detention. And any failure not to do so can, so we have to look at the facts of each individual case, can render their detention unlawful. In an interesting case to look at is that case of SW. So I flagged it up, and I'm not going to go into any detail, but these are all short flags for you to be able to look things up if you need to, or if you come across them in relation to your client. So going over to the next flag, I wanted to just flag within the rules, if you look at then a Rule 35 report, what are you looking at? What are the things that are being looked for when a Rule 35 report is being prepared? Of course, an examination under Rule 34 can only take place with the consent of a detainee, and it will be all the concerns that a medical practitioner might have will be set out in this Rule 35 report. And it should record or any matters of concern, particularly as I've set out those three elements which are found within Rule 35 of the detention centre rules should be set out. So if someone is likely to be injuriously affected by continuous detention, then that's considered as quite high-level evidence, what's known as level 3 evidence, and I'll try and explain the different levels in a moment. Then, of course, anyone who is suspected of having suicidal intentions, they have to be placed under observation, but of course this also must be recorded within a Rule 35 report. And then, of course, anyone who's been a victim of torture, if they make that declaration, this, and it's recorded in their Rule 35 report, this is seen as level 2 evidence. Now, important to look at also is the adult at risk policy. It highlights indicators of whether an individual is going to be particularly vulnerable to harm. So those are known as risk factors, which should alert someone who is assessing detainees whether those risk factors exist, and then to go on to make those assessments in relation to Rule 35. So as I've said, set out there, as I've set out there, once an individual has been identified as being at risk, then they need to be assessed in relation to whether or not their continued detention is appropriate. And the guidance, and I'm sorry for the spelling mistake there, but if you look at page 14 of the adult at risk policy guidance, it will provide you with the different levels of evidence that can be produced or that may be seen with reference to individuals who have certain risk factors who are being detained. And it's important to ensure that we are familiar with this so that we can look to ensuring that we have that evidence if we are looking for our client to be released from detention. And I'm sorry, this is quite a whistle stop, but it's just to flag the different kinds of reports. But we also have independent medical legal reports. A lot of individuals who are being detained, we will, or as solicitors or our clients will advise our solicitors to ensure that medical legal reports, independent ones, are obtained to ascertain the exact condition of the clients. And I think it's already been covered what medical legal reports ought to, or what your instructions must focus on, but it's also worth looking at the adult at risk policy because it provides you with a focus on the definitions of who could or who is to be considered vulnerable. So you know to flag what factors must be flagged, or what factors you might want to ask the medical practitioner to focus on, to look out for whether or not your client's suffering with those and the impact. And of course, the guidance also highlights that there's got to be very strong reasons to disagree with any kind of medical legal report that's produced. Now, that's all well and good, but often we would see that that wasn't happening, that reports were being disregarded. However, recently there was substantive litigation. It's a case called AK. It's not been reported, but it is in the public domain insofar as counsel who was dealing with that case has counsel and solicitors have published the various guidance and statements of reasons and consent orders, in fact, in relation to that particular case. But it revealed through that litigation, it revealed some unpublished guidance in relation to medical legal reports. And it's really important that we look at that unpublished guidance when we are looking at our clients who are being detained, because the guidance was consistent with what the adult at risk policy says, in that individuals ought to be released, that if medical legal reports are produced which say an individual's at risk, then they ought to be released, that it ought to be considered at a certain level of evidence, and they ought to be released in accordance with those reports. In this particular case, just to flag, there was a report by the detention centre, or the professionals at the detention centre, which was conflicting with the independent medical legal report. But the courts found that even where there was an inconsistency, this report ought to have been preferred because of the level of the practitioner who'd produced the report, and as we always go back to what KV says, the significant potential value, and the fact that the report had actually complied with the Istanbul Protocol and had produced a report in line with all protocols necessary. So it's worth having, if you are having difficulties in relation to any medical legal release of your client, to produce your own reports, but also look at the unpublished guidance which provides support for release of your clients once you produce the medical legal report. And that just takes me to the next slide, in which I've highlighted the documents which were disclosed in the Freedom of Information disclosure. The link there should take you to all those documents, and you'll see the various emails, the email chains between individuals within the various Home Office branches. This is all in the public domain, so it's something that can be used and is widely known about with reference to the way in which these reports ought to be treated. So definitely worth having those as part of your resources, essentially, in relation to any detention claims that you might take. And I think that just brings me to the last slide, and I'm going to hand over back to Sarah. Thank you.
Thank you, Samina. Again, I think we're not reaching the time when important policies, important guidance remains unpublished. It happens again and again. So to leave time for questions, I'm only going to run through these last slides very quickly, really just as a highlight, as a flag to be aware of perhaps what's to come. And then also sort of giving a bit more practice, best practice tips in terms of instructing experts, and hopefully Juliet won't shout at me for saying something wrong on that basis. But the new plan for immigration highlighting here, so this link here that you have is to the consultation document that obviously has now been superseded by the new Nationality and Immigration Bill, which is now making its way through Parliament, reaching, I think, imminently, I think tomorrow, maybe in 2 days' time, the committee stage where the committee will hear evidence on it. So it's a bit superseded on that front, but we wanted to flag that within that plan there was announced a proposal for a new system of effectively a panel of pre-approved experts, including, as you can see there, medical experts. And those experts would then report to the court or the system would require such experts to be jointly agreed by parties. So this, obviously chimes perhaps with other jurisdictions in terms of civil claims, where you will have much more of a system in terms of joint instruction. But it's also a jurisdiction where there's perhaps more resources, more privately paid, and insurance covers that's obviously very different from our jurisdiction. It wasn't brought forward, so that is some consolation initially in the Nationality, and Immigration Bill. Flagging here, there does seem to be talk of a decision-making function in the Home Office with a board of experts for age assessments, but that's a very different context that we're dealing with today. So I just flag it there. And again, it's a proposal because this clause in the bill is a placeholder clause, so it's not been finalised, bizarrely, despite being included in the bill. But that's that. And what we do have announced within the government's response document, which again is highlighted here, and you have the hyperlink to the consultation on the new plan for immigration, is that the government has decided not to establish a panel of experts, but intends to take forward work on the joint instruction of experts in immigration and asylum proceedings through proposing changes to the immigration procedure rules. So that's all that we have now. So there may be less talk of a panel, but still an idea or a system of joint instructions, and who would sit, who would be qualified for those instructions. That remains to be seen. How obviously joint instructions would work in practice, funding wise and so forth, and obviously how it can then be considered by tribunals. So watch this space. Hopefully obviously that will be fed in any event with all the relevant stakeholders. But we just wanted to flag that seemingly important to the government because it's not been completely shelved. And so that's a bit about what's next, but coming back to practice direction. So you heard of the practice direction for experts being referred to by Charlotte in her talk on KV. And that was in the context of the Court of Appeal, basically saying at that point in the litigation that that was really the only document that needed to be consulted by experts. The practice direction is well established now. It hasn't changed for years. You have it there as a link. Most experts that we instruct should be familiar with it, but again, it's best practice to highlight it, to remind them, and to make sure that those parts and parts of the report, but also the parts of the practice direction are compliant with it. So I've just summarised it there. It's paragraph 10 of this practice direction, because it's a practice direction that deals with all sorts of other issues. paragraph 10 onwards is the expert evidence. 10.1, duties for the party to instruct. So again, it's a practice direction for both sides of the instruction. So bear that in mind when you prepare your LOI, your letter of instruction. And then 10.2 to 10.6 effectively covers the duties of the expert. So I've only paraphrased that there for you. So do go to the source material if you're not familiar with it. But again, really best practice should cause you to sort of check it every now and then, even if you think it's not changed, against your template paragraphs for your letters of instructions. Highlighting the independence of the expert, that their duty to assist the court is paramount, overrides any obligation to anybody else, overrides any issue of funding, overrides any pressures of litigation, and then also highlights the sorts of information that should be made available to the expert, and how the expert should summarize that, should sort of recount that when it's particularly relevant to their conclusions. So useful to go back to, even if it is sort of well established and perhaps part and parcel of the jurisdiction. And then you have 10.9, as I said, the required content of the report. Now, I don't think a judge will necessarily go through a report and say, oh, I can't attach weight to that because it doesn't have X, Y, Z in compliance with the practice direction. And as you heard, Juliet also mentioned, even if a reporter does not necessarily expressly refer to the Istanbul Protocol, it should still be taken into consideration and due weight attached to it. But nonetheless, I think if we can all abide by best practice, it will make for an easier run in the appeal. And then I just wanted to highlight in closing really the other practice direction which may be useful in this context, which is the Joint Presidential Guidance Note on Child, Vulnerable Adult and Sensitive Witnesses. So that is more a practice direction for judges in considering, in assessing evidence from such witnesses, but does have some useful that you could draw attention to the expert specifically to sort of prompt consideration of certain issues, and also for the expert to expressly deal with. That may then also inform the judge and how the judge should address the witness, how the judge should consider that witness's evidence. So both, I think, interlinked can be very useful tools, both to sort of prepare an assessment and then obviously how to carry forward the conclusions of that assessment. But I just highlight here at the second half of the slide, I won't speak to it similarly, but SB Vulnerable Adult Credibility, a fairly recent decision of the tribunal that effectively says that being vulnerable doesn't sort of trump adverse credibility findings, if I can put it so ineloquently, and so do be cautious there, and if there is an issue concerning those sorts of difficulties, do look at SB more closely. So that's my little run through, and wish to thank you for your time. You have all of our contact details there in the last slide in Chambers, and we will now turn to the Q&A. So I'll just stop sharing for us to come back all together. And I think we've got one Q&A, so just bear with me. So I've just hit answer live, so that should come up on everybody's Q&As if they want to have a look at it. Does Freedom from Torture have specific services for LGBTQ, I'm just going to say plus, people who faced torture in their countries of origin, facing questions on credibility of identity as well as torture? How does it change, or how might that change Freedom from Torture's approach? Juliet.
Thank you. Yeah, good question. So we've all had training on the DISH criteria, and what I tend to find is that when we're instructed for this kind of claim, we're instructed to look at the experiences of harm. And so I think our job as medical experts is to focus on the experiences of harm. The psychological harm will relate also to experiences of discrimination, shame, stigma, which will have affected people, but often also they have been physically harmed and will have their own psychological responses to that too. So that doesn't quite come to credibility of identity, but what we try to look at is just within those criteria, and particularly about psychological and physical harm. I don't really feel that I'm qualified to say, yes, this person is gay or lesbian or bisexual. That's not my role. I've seen reports from people who work in support organizations who will write reports confirming that, in their opinion, the person does that have sexual orientation or gender identity. But I don't really feel that's the medical expert's role. But we certainly see many people who are making an asylum application on that basis.
Thank you. That's really useful. I think that's the only question so far. In terms of, if I may, Julia, I had a question just to see how we can sort of best deal with it in practice. And that's the issue of very often, perhaps more from the Home Office end of things, and I don't know if you've seen that in your training at the Home Office, the rejection of a report because the expert takes the account at face value. So Charlotte touched on that obviously with KV, and there is much case law about that problem, but it seems to come up over and over again, and I just wonder, is there a sort of a way out of it not coming up again?
So yes, it's very frustrating to see in these decisions citations of incredibly outdated case law from decades ago, and they're still doing that. Particularly the further submissions team are doing that. What I do when I am asked to write a response letter where this has been an issue is I would refer to the introductory paragraphs of our reports, which will contain a statement that the opinions are based on not just the account given, but also the responses to clinical questions asked, due examination findings, and observations throughout the assessment time the doctor spent with that person. So and a reminder that the statement of truth within that report also is an undertaking that the person is presenting an objective and impartial opinion. But there's also a reference to this in the asylum policy instruction that the Home Office has signed up to, which is that clinicians are, with the requisite experience, are recognised as objective and impartial and as giving their expert opinion. So I think you can refer to that as well. Will we continue to see it? Well, I hope less and less as we keep on with the training.
Thank you. We've just had one other question come in. At a practical level, would you prefer the legal rep to be in attendance during the assessment, brackets to assist with clarification of facts, or can it be problematic if the client is looking to the legal rep to help answer questions rather than answering themselves?
No, I would not prefer that. I think the assessment needs to be with the minimum number of people required, which is the doctor, the applicant, an interpreter who may be present in person, or more and more nowadays they're only on a phone or video link, and sometimes a support person who is there in a non-speaking role. Sometimes I'll ask that person questions if they have direct experience, for example, of difficulties that person has in managing everyday activities, or has witnessed them waking up from a nightmare, for example. They can provide some corroboratory evidence about the clinical state of that person. In terms of clarification of fact, or I think what really helps the report process to go well is when I've got a great witness statement, which already clarifies anything that's come up in the asylum interview, the screening interview, and any decisions that have been made so far, and addresses any inconsistencies and deals with them. If I've got that, then I should be good to go. very often now, because of the intense scrutiny that this kind of evidence is placed under, I do find legal reps coming back after a report and say, look, I've read the report through, and actually now we just want to clarify this one particular issue where there's a slight difference in detail, or could it be more precise, or whatever. And in that situation, it's either very obvious what the clarification is and I can make an amendment, or I'll have a quick phone call with the client and check with them exactly what the clarification is needed or not. Or I can discuss the difficulty of an inconsistency that's now become apparent if there's a new witness statement, for example, and we can talk about memory and recall and all the difficulties of remembering trauma and remembering other information and recounting it in the same way each time and so forth. And there's loads of good references on memory difficulties, particularly guidelines on memory in the law from the British Psychological Society. That's a great reference to use in that respect. So yeah, that's how I would address that.
Well, that's really useful, thank you. And how do you, I mean, do you welcome sort of interjections from solicitors after, or legal representatives after the event, in terms of efforts to clarify something, or is it sort of, it can be difficult after, depending on the period?
So speaking for myself, because I do independent reports also, I don't have a problem with it, because I want the report to do the job that I want it to do. If something I've written is not clear, or if there's an inconsistency that I haven't addressed within the report and it needs to be addressed, I don't have a difficulty with that. But it's a massive time saver for both of us if everything that could be brought to my attention is brought to my attention before the assessment rather than later. But, you know, in real life, people often do suddenly say to the solicitor, wait a minute, no, I didn't mean to say that, or now I remember it better. Actually, it was this way, and that's fine. Freedom from Torture as an organisation has its own internal review processes, and it has a legal review of each report before it's issued. So probably they're less keen on then going back over everything, and you might find a little bit more resistance. But if there is a specific clarification, particularly if something's been missed, and we're all humans, we can miss stuff that, you know, was clearly set out in documents, and the report writers missed it, then of course we would make that clarification.
I was just going to ask a question, Juliet. We often see, or we've often asked for fitness to give evidence elements in our report. Is that something you do as a standard, or would it be something specific you'd be asked in instructions to comment on?
So it normally comes now as a specific instruction. Sometimes even without an instruction, we'd include it in a report because it was so obvious that the person had enormous difficulty giving their account or responding to specific questions about the most traumatic parts of their experiences. And so the doctor would automatically include some warning saying, you know, don't ask them about this because they'll faint or vomit or whatever. But it does increasingly come up in questions in the instructions. And so then, yes, if it's there and we've got something relevant to say, often it is quite general, just, you know, this is a vulnerable person, and you should make sure they have enough breaks, and that you ask questions in a straightforward, simple way, short phrasing and so forth, to enable someone with difficulty concentrating to understand what it was you were asked. Because I think a lot of the problems arise when people ask a complex question with several parts to it, and the person just answers really quickly to get it over with without really thinking through what was meant to be asked them, or the interpreter perhaps loses some of it in translation and we don't even know. So people are judged on the answer they give, and that may not be fair.
And we've got one other question in the Q&A box for anybody who fancies taking it. How do we define a victim of human trafficking in conjunction with a Rule 35 or an MLR?
So I'm not sure there's an accepted definition of human trafficking. There are indicators that someone is a victim of trafficking. I don't think the IRC doctors who write Rule 35 reports have a lot of training on trafficking, and they don't tend to identify those indicators when they take these very, very brief histories of events for the Rule 35 report. So you won't find a lot of indicators there. All you'll probably find is says he was a trafficking victim, or says he was trafficked, or says she was trafficked. So that's not really going to be acceptable as a definition. The best information comes from a trafficking expert who's worked with the victim over a series of assessments from the Poppy Project or whatever, and has got a lot of detail of all the different elements and indicators of trafficking that have been revealed through talking to them. And they will help you, I think, enormously in preparing a witness statement that documents all of that information. In terms of the MLR, what I would be usually asked to do is simply look at the instances of harm and the physical and psychological impact of the experiences of harm, rather than make the determination about trafficking or not trafficking. And so often now what we're seeing is people who've got torture, trafficking, other experiences of abuse and exploitation, and there's a whole range of different experiences of harm. And sometimes it's really difficult in the MLR to say what are the relative contributions of these different experiences of harm in what are the endpoint findings that I can identify now.
Yeah, especially with also things happening along the way in terms of journeys to the UK, and the sort of the more closed that is, the higher risk of that happening as well, entirely separate to often the reasons as to why a person fled their country in the first place. Well, thank you all. Are there any other questions from Samina and Charlotte? Any final words from Juliette? No. Okay, so that's it for other questions from our listeners and watchers. So thank you, everybody. Thank you, all three of you, for joining us today. And we hope to our attendees that was useful. And we wish you a lovely, sunny at my location, rest of evening. Thank you.